Good afternoon and welcome to Day 2 of the Media Freedom Rapid Response Online Summit, which is this year taking place under the banner Boosting Press Freedom. Each summit day, we focus on a particular aspect of the MFRR's work in defense of press freedom and media pluralism in the EU member states and candidate countries. Today, legal threats are in focus. We will start our deep dive with a keynote address by Matthew Caruana Galizia. He will address the role of public inquiry in seeking justice for the assassination of investigative journalist Daphne Caruana Galizia. At 2 p.m., Article 19's Head of Europe and Central Asia, Sarah Clark, will moderate a panel on strategic lawsuits against public participation, or SLAPs, which will look at the latest legislative and policy developments at the European Union and Council of Europe levels, with policy experts and affected journalists. At 3:30, Neos Vidal, monitoring officer at the ECPMF, will chair a discussion panel which, under the title Access Requested, will focus on the most common difficulties faced by journalists when using Freedom of Information Acts to request data held by public authorities, and the main steps that could be taken to ensure that it is published when requested. At 4:30, we shift the focus away from the MFRR region and onto the impact of the war in Ukraine on journalism, with an interview with Vladimir Motorin, editor-in-chief of Dost, an independent Russian TV station, by ECPMF's managing director Luhze. At 5 p.m., we close Day 2 with a workshop on navigating practical support, where we will present Press Protect, our new website that gathers different support offers from organizations all over the world for journalists and media workers in distress. The workshop will also be an opportunity to talk with people behind our legal, practical, and relocation support. All of today's sessions are streamed and accessible for all except the workshop. This takes place on Zoom and requires registration. You can still sign up via the program's website on mfrr.eu. First, however, I'm pleased to pass the floor to Marie Freinet for a message on behalf of Vera Jourova, Vice President of the European Commission for Values and Transparency.
Thank you very much, dear Lorenz. Good afternoon. Good afternoon, dear Matthew. Good afternoon, ladies and gentlemen. Indeed, unfortunately, the Vice President is unwell and she cannot be with you today, so I will say a few words on her behalf. First of all, I know that she really wanted to thank you for the work that you are doing, the very important work that you are doing to support journalists in Ukraine during this atrocious war launched by Russia against Ukraine. This war has shown more than ever the importance of free media, and it has showed the importance of projects such as the Media Freedom Rapid Response, which brings together media freedom organizations. Our first common priority is the safety of journalists. 4 journalists have been killed since the beginning of this war. More have been injured. More are threatened. They are under fire, under Russian fire, and this is unacceptable. Journalists should never be a target. The international humanitarian law is clear on this, and it should be respected. But in a context where some do not respect any rules, we have to come with support. The European Commission is spending around 5 million euros on protective equipment for journalists, on the salaries of Ukrainian journalists, on cybersecurity, on psychological support, and also on relocation when it is needed. And more EU funding will be provided in the coming days. We also need to think about the protection of independent journalists from Russia and Belarus who have to flee their countries. These journalists can be very important voices to reach out to Russian communities in Russia, even though we know how close the space is right now, and to reach out to Russian communities outside Russia. But unfortunately, journalists do not only die in war zones. And I think in particular of Daphne Caruana Galizia. Journalists have been murdered here in the EU, and we need to act. And I know that Matthew will speak right after me. The Vice President is urging member states each time she can to implement the recommendation of the European Commission on the safety of journalists. We are monitoring the situation across the European Union including as part of our rule of law report. And I know that many of you are contributing to this report, and I would like to thank you for this important contribution. The Commission is also working right now on a directive and a recommendation to tackle abusive litigation against journalists, the so-called SLAP. We aim to come with this package at the end of April. I know this is a topic that you will discuss in details later today. Another very important step is the Media Freedom Act. Our aim is to come with safeguards at EU level to protect the independence of the media and the pluralism of the media. We see media companies are not just another business. They need and they deserve specific protection, and this is what we are working on right now. The Vice President is working hand in hand with Commissioner Breton on this initiative, and we aim to present it in the summer. Once again, we need your support and we need your contribution. There is now a public consultation ongoing. It has been extended until the end of this week. And if you have not done it yet, please participate. We really would like to have your voice heard in this debate. The Vice President and her team, including myself, we are looking forward to continuing working with you on these very important issues for our democracy. Thank you very much. I wish you very fruitful discussions.
Thank you, Marie. It's difficult to not start by saying something about what's happening in Ukraine. I'm deeply grateful for the work that journalists there are doing to bring us information on Russia's illegal invasion of the country. And we're currently engaged along with other organizations in doing whatever we can to assist the journalists who are there on the ground, as well as the families of those journalists who have been murdered. I see this as an immediate need right now, but we can't, of course, forget that what is happening there started a long time ago. And there is a place in this discussion for slaps, especially as journalists who attempt to report on corruption in Russia, who attempt to report on war crimes by Putin, are themselves sued and themselves face attempts to shut down their work, both in the form of censorship by the state and self-censorship by their own publications. Back to the work of the Commission, my family and I are deeply, deeply grateful for the support that European institutions are showing for free and independent journalism. This is a really big change, both for my family and I think for journalists across Europe. Things were very different 5 or 10 years ago. I myself have faced nowhere near the number of lawsuits that my mother faced during the course of her career, or that other journalists around Europe are facing. I'm only dealing with 4, which might seem like a lot, but in comparison to the more than 40 that my mother was dealing with, in comparison to the hundreds that European publications are dealing with, this is nothing. How did my mother end up dealing with so many libel suits? They started slowly, and I think without wanting to blame the victim, they really began as a result of my mother pushing the limits of what was possible in Malta, which I think she saw as a public service, as a duty to her country, which was stuck in a cycle of political corruption and of conservatism. As many people listening have probably learned over the years, due to the attention that has been focused on her case, my mother wasn't like most people. While many citizens in our country seek security, shelter, material well-being, a roof over their heads, my mother sought meaning in life and other things. And I think she had that in common with many other journalists around the world whom I've come to know over the years, like those same journalists who are now showing great courage documenting Russia's illegal invasion of Ukraine. These are people whom I wish that she had the opportunity to meet at some point, so that she'd have realized that she wasn't so alone. As with most things that get out of control, I'm speaking about the tens of libel suits against my mother. This legal harassment is something that actually started a long time ago. And I think that this is something that most journalists who have had a career as long as hers can relate to. Legal abuse is something that they've been dealing with for a long time, but has ramped up. Going back to the 90s, a time that now feels like a century ago, my mother was a working mother in her 20s, trying to balance her career and education with the needs of 3 young children. And my brothers and I would sometimes find ourselves in the back of her car, going to interviews and meetings with her, meetings with editors, meetings with sources. This is how, at the age of around 9, I learned how powerful people who want to avoid public scrutiny use legal threats to coerce the media into self-censorship. I remember sitting in the back seat of my mother's beige Citroën AX, parked outside the office of our country's biggest newspaper, which had published her bi-weekly column. The first column to be published in Malta under someone's real name and not a fake name. She was the first woman to write such a column and the first person to do so under her own name. That column was the only reason that many people bought the newspaper. From the very beginning of her career as a journalist with that newspaper. I remember seeing my mother coming out of the building furious, and we more or less gathered explanations, my brothers and I as young children gathered explanations of what happened from my mother and from overhearing conversations over the next few days. This became my first lesson in self-censorship. What happened was that the daughter of a senior politician in the governing party was representing organized criminals and drug traffickers in court by day, and using her influence over senior ministers, including her own father, to procure state pardons for the crimes of her clients on their behalf. Everyone knew that this was happening, at least among political circles, among journalists, but no one dared speak about it openly, except for my mother. She was determined to break the silence. Her editor refused to publish her opinion piece on the matter. My mother resigned on the spot, took her piece to a rival newspaper, and got it published. A few years later, a tow truck turned up outside our house. The lawyer that my mother had written about had filed a libel suit against my mother and used the claim to freeze all her assets, including her car, which she intended to seize with that tow truck. Few people fought for my mother at the time. I remember a great sense of isolation, and that my mother was completely alone. My family was completely alone in this fight. There were no civil society organizations at all. There were no politicians speaking up against the abuse of the law. No human rights lawyers jumping to my mother's aid. After that, my mother did the only thing that she could do in that situation. She became bolder. She was determined to stand up to bullies, determined to stand up to those wishing to censor her with legal threats. And this was a lesson that my family and I learned through my mother's fight by proxy. But with a lack of international attention, the situation in Malta festered. The subjects of any kind of public scrutiny realized that they could shut down that scrutiny with a few letters from an aggressive lawyer. In the last year of my mother's life, when it felt like we were at the start of a new marathon run against corruption, my mother told one of my brothers that it felt like she was being fried alive. There were vexatious tax investigations against her, many libel suits, other kinds of legal threats coming from law firms in London and the US. And I could feel the same thing by proxy. I could see the effect of the legal conspiracies against my mother, the wasted days in court, the lack of respect for people from the judiciary, the massive amounts of money that she was spending on simply filing submissions that she was contesting the claims against her, the frustration at the lack of support from fellow journalists. It's important to point out that in Malta, unless you file a submission to contest a libel claim against you, you will lose by default. So every single claim has to be fought tooth and nail. This was affecting both my mother's health and her journalism. She was losing sleep, dealing with intense stress and anxiety. Every day felt like a battle. We were dealing with the possibility, because by that time I had begun working with my mother directly, that she would have to abandon her work altogether. These are the same symptoms of stress and anxiety that I see in many journalists that the Media Freedom Rapid Response Group assists today, which is why Flutura Kusari, who works as part of the group, says slaps ruin lives. This is something that I can really attest to. After my mother's assassination, I felt that we were fighting an uphill battle. I had an overwhelming sense of exasperation. Sometimes it felt like the situation was hopeless, that it was something that we would never be able to do anything about, a kind of torture that we would have to learn to live with. I had seen slaps, quite literally. I was there when a bailiff was sent by the courts to present my mother with 19 claims against her at one go. My mother wasn't home. So the bailiff got out a roll of tape and tried to secure around 100 pages of these claims to the front gate of our house. When my mother came home, they were in shreds all over the ground. Our dog had ripped them apart. He was a good boy. The 19 lawsuits had been filed against my mother by a single person, a hotelier who was a major donor to political parties in Malta. In speaking about him, my mother was breaking a wall of silence that protected the activities of this business figure from scrutiny. She couldn't stand the silence and saw it as her duty and a service to the public to throw light on the links between business and politics. I had seen slaps, felt them, and fought them alongside my mother. But how would it be possible to communicate this experience to others if they had never felt it themselves? Few even knew what the term meant, and we were advised by many campaigners we consulted that we'd have to come up with a different word, a different slogan. We considered this advice and then decided to ignore it, and I'm glad we did so. We've reached a point where we no longer have to explain it to policymakers. The word slaps is used in the corridors of parliaments in Spain, Portugal, Italy, Germany, and the UK, and across the Atlantic in the US. A few days ago, we found out it had reached the European Court of Human Rights. The word slaps made its first appearance in one of the court's judgments, probably one of its last ever against Russia. How did we get here? It has been a long campaign that for me started at an international level in 2017. Aside from thanking the Commission, I have to thank the many press freedom organizations, environmental organizations, campaigners, journalists, activists, and lawyers who have supported victims of slaps and helped communicate this collective experience of lives ruined around the world to political leaders. Attention is rightly focused on the immediate and urgent needs of journalists on the ground in Ukraine and of those who have been murdered during the course of their work there. But those journalists had raised the alarm long ago. Anna Politkovskaya covered Russia's war crimes in Chechnya, raising the alarm about Putin decades ago. and she was murdered for her work, as were her colleagues, in retribution for reporting on crime and corruption in Russia. In the heart of Europe, journalists like Catherine Belton are sued for everything they own. Their publishers are always sued, creating pressure at the corporate level. We have to do something to stop this. Unless we create a freer environment for freedom of expression, unless we allow journalists wherever they are to freely report on crime and corruption, the situation will only get worse. I think that what we are facing is an immediate threat to democracy itself, and not simply a threat to journalists alone. I have heard criticism that what we are attempting to do is create a privileged class of people called journalists and isolate them from any scrutiny. That couldn't be further than the truth. It is completely the other way around. Journalists are themselves the voices of the public. They are themselves the canary in the coal mine. If journalists are unable to report freely, then the public is unable to know. So protecting journalists is not creating a privileged class of people. It is protecting all of society, protecting democracy itself. Thank you for listening.
Good afternoon, everybody. My name is Sarah Clark, and I lead the Europe and Central Asia team for Article 19, who is a partner of the Media Freedom Rapid Response. A very big welcome to day 2 of the MFRR Summit and our session on pushing back against slaps, advancing protection against legal abuse. Good afternoon, everybody. My name is Vera Jourova, and I lead the Europe and Central Asia team, who is a partner of the Media Freedom Rapid Response. Sorry, I'm just getting some feedback here. Very big welcome to day 2 of the MFRR Summit. Just hang on for 1 minute. And our session on pushing back against slaps, advancing protection against legal abuse. Good afternoon, everybody. My name is Vera Jourova, and I lead the European Central Asia team, who is
Hi, my name is Vladimir Motorin. I am the legal advisor of the European Center for Press and Media Freedom. Obviously, we have a technical problem. We'll wait for Sarah to rejoin. Meantime, I'll contact our technicians and see whether they can help.
Hi, everybody. I'm very sorry about that. Let's just kick off again. Welcome to the MFRR Summit, to our session on pushing back against slaps. We're delighted to have an excellent panel today, all experts, either because unfortunately they've received slaps or are working to push back against slaps, both at the legislative and in terms of journalistic support. We have today Julia Nebel, who's the director of Luhze since August 2021, which is a newspaper in Leipzig. We have Miguel Roig, who is the deputy editor of El Confidencial, and his colleague Ángel Villarino, who may be able to join us a bit later, who's the deputy director. We then have Flutura Kusari, who is the legal advisor for ECPMF, and Julia Luhze, who's the secretary of the expert committee on slaps at the Council of Europe. So to kick off, we have Julia Nebel giving us a case study on the experience of Luhze newspaper from Leipzig and their experience of slaps in Germany. I just want to say very briefly to the audience to please submit your questions. We'd be delighted to engage with them. Thank you. And over to you, Julia.
Thank you. How serious everything was, we recognized on the morning of the 24th of December. That morning, we received an email with a written warning which wanted us to delete several passages of an article published in the December issue of Luhze. We were shocked, as it was Christmas, and we were confronted with a legal dispute with United Capital, a real estate company. But who are we? Luhze stands for Leipzig's Unabhängige Hochschulzeitung, the independent university newspaper of Leipzig. That means Luhze doesn't belong to one of the universities. It is self-organized, created by students. So am I, the director of the association which publishes the newspaper. Of course, I am not alone. About 30 persons currently work for Luhze, everybody besides studying in side job without being paid at all. By selling advertisements and gaining donations, we finance the costs for running our homepage and printing our newspaper. We deliver Leipzig and its students with news about campus life science and what's going on in town by articles online and in our 4 issues per semester, as the one from December 2021, which contained a, we later learned, fateful text. The article with the translated title, Affordable Housing, Dispute over United Capitals Abroad, took a critical look specifically at one of the residential buildings where United Capital purchased apartments. The article has equally reflected the perspective of United Capital as well as that of the local residents who made some accusations about the company's approach. What the company does is buying apartments, remodeling them to create an extra room, and renting the rooms out furnished, especially to students, for 18 euro per square meter, which is pretty expensive by Leipzig standards. The residents mentioned in the article that United Capital used different methods to get rid of the old inhabitants of the apartments for remodeling them into students' rooms, such as phone calls and text messages all around the clock. After the article appeared on the 6th of December, printed and on the homepage, United Capital got in contact with the author and wanted one passage in particular to be deleted, which said that United Capital was wearing down the tenants by constantly trying to convince them to move out. However, our author was overwhelmed with the situation and not at all in the position to make decisions on the upload of articles or whatsoever. The two editors-in-chief of our newspaper wrote thereupon an email which led to no result. We were told that their lawyer would contact us. Then, on the 23rd of December, shortly before 11 o'clock at night, their law firm Ronneburger Zunft sent us a written warning. We read it, as already mentioned, the next morning and were all quite angry about the timing and about the fact that United Capital aimed to put us, an unpaid students' association, under so much pressure via this letter. It wanted us to black 5 passages and pay 2,000 euro attorney fees. All this until the 30th of December. United Capital saw itself injured in its personality right as a company and designated the passages as untrue facts. Thus, our Christmas holidays were screwed and we were extremely stressed. Most of us were not in Leipzig, but all over Germany at their parents' homes and celebrating Christmas. So it was difficult to coordinate, but we had to meet decisions soon. There was a deadline, the 30th of December. Furthermore, our opportunities were extremely limited. Even if we had liked to pay for having peace, we actually didn't have 2,000 euro on our bank account. So we wrote a counter letter saying we wouldn't pay at all and that our reporting was, of course, well investigated. Thereafter, United Capital's lawyer gave us on New Year's Eve an extension until the 3rd of January, 10 a.m., for paying and blackening the passages. This period again included 2 holidays, so really generous. The next surprise appeared on the 6th of January. Opening our letterbox, we found an application for a temporary injunction. United Capital had filed it already on the 3rd of January. The district court had scheduled a hearing for the 21st of January, 2 weeks from then. Now we knew it would become really serious and that our hopes, United Capital would drop the thing if we didn't give in immediately, were naive. We really questioned ourselves if we made the right decisions until there. The district court, Landgericht, instead of the municipal court, got in action because of the high amount of dispute the lawyers of United Capital had said in their writings. That were 50,000 euro for the principal proceedings and 25,000 euro for the summary proceeding. But a hearing in front of the district court proposed the next problem. Now we were finally obliged to employ a lawyer, and we were under great time pressure. The court had given us about a week to state our objections via a lawyer. You can imagine, on the 6th of January, the day we found the application in our letterbox, we felt really stressed. Normally not confronted with those legal problems and really fearing high costs, it was just luck that we found a law firm just the next day, which in the end appeared to be competent and was willing to support a low-budget students' newspaper. There was a reason for the sympathies of the lawyer for us. He himself had been editor-in-chief of the Law Students magazine during his study time, he later told us. Now, legally supported, we were of course relieved, but had to go on doing research, preparing the hearing. United Capital had blamed us for apparently publishing wrong facts about them. but finding evidence we could use in court wasn't easy. For example, inhabitants of the flats of United Capital who had talked to the Luhze author before strongly wanted to stay anonymous and couldn't be convinced to be witness in court because they feared consequences from their landlord, which was United Capital. So we decided to involve the public and released a press announcement on the 15th of January. Soon we had several requests by regional and supra-regional media. The public interest in our case grew. We never had more visits on our homepage than in these days. Hello, Streisand effect. And people donated money for a trial without being asked for. On the 18th of January, the lawyers of United Capital for the first time showed an interest in a solution out of court, as they said, to protect us from high costs, but held on their demands in general. So we waited, talked to several reporters about our case, and a political group in Leipzig announced a demonstration in front of the district court for the 21st of January, Friday, to support us. In the evening of Thursday, the 20th of January, we surprisingly received an email from the managers of United Capital saying they would withdraw their application. This indeed happened the next morning, the morning the hearing in court should have been. Some weeks after these events, we met the managers of the company for a clearing conversation. Revealing was the manager's understanding of the press. Good press is the reporting that supports the company and its business interests, or at least doesn't touch them. But what scratches the company's image is instead automatically bad press and has to be improved or deleted, but is not acceptable. Thank you.
Thank you, Julia. And that's a very good news story and a great example of how advocacy in media can be used to really pressure plaintiffs to drop these sort of vexatious suits. Unfortunately, in the case of El Confidencial, as Miguel and Angel are going to describe, they are still facing an absolutely enormous case for their reporting. So over to you, Miguel and Angel.
Yes, I think Angel will explain a little bit Confidencial, and I will explain a little bit the case in which we're involved.
Fantastic. Thank you, Mikkel. Thank you for hosting us here. El Confidencial is a newspaper that was born 20 years ago. It's an online newspaper. We don't have a print edition. And we reach top of the market. I mean, we are in, there are like 4 or 5 newspapers in Spain, which are leaders in terms of audience online. And this, I'm saying this because it's not very common that an online newspaper born online without print, any print edition, reach these numbers. And I think that we are well known in Spain precisely because we are free. We are very free. Because we are well known for our freedom, not only because we don't take political sides, but also, and probably the most importantly, because we write about companies, all kinds of companies, with great freedom. That is something that is not very common, I guess, in any country, but for sure it's not very common in Spain. Since the beginning, this has been our big advantage with our competitors, but it's always been a big challenge because we have suffered all kind of pressure from the economical powers every month, every year. I guess every month, or probably every week, we get a letter from the lawyers of one of these big companies that we write every day about them. And Mikel is the person who suffers most of these pressures because he is in charge of the economical news of the newspaper, business news of the newspaper, and I'm sure that he will explain much better than me how is the daily how we deal with this daily pattern that we have with the companies that the news we publish in the newspaper, and with the case of Iberdrola, which is the case, the most important case we have in the last, not the only, we have many others with big amounts of money, but I think this is the one that concerns us more in this moment. Mikel.
Oh, yes. As Angel was saying, I mean, we are very used to receive lawsuits because we are well known in Spain for publishing very freely about companies, business, and persons with real, big power and money. The thing is that this amount of money that we have been demanded is unprecedented. That's the thing that is the thing that preoccupy us the most. No? What happened is that I mean, because just for you to understand what's the situation, we are a newspaper in Spain online, 21 million euros in revenue per year, and then there's Iberdrola. It's the second Spanish company in terms of market capitalization. We are talking about 60,000 billion euros in market cap, around 3 billion euros in profits last year. So you can imagine that they don't have any problem in hiring lawyers to that. So what happened is that we ran an investigation 3 years ago actually, and then we start publishing how this company allegedly, because we got access to plenty of documents and audio files, this company allegedly, of course, hired a Spanish policeman, commissioner of police, and in order to spy and get information about competitors, politicians, rivals, and so on, you name it. So we published, following all the rules of journalism. I mean, we talked to every part involved. We gave them opportunity to give their version and so on. Blah blah. We of course verified the authenticity of the documents and the audio files, everything, and then we published. So what immediately happened after that was that the company canceled any commercial relationship that they had with us. Of course, they cut the publicity and so on and agreements. So okay, they are in their right to do that. We can disagree, but of course, it's their money. What's the game changer? The game changer was 3 months ago. I can't remember actually. Sorry. But we received a formal letter from a court in Bilbao, that it's the northern city in Spain, in which Iberdrola has the headquarters. And this letter said that Iberdrola has sued us for damaging its image and reputation. And they attached like a report or like a research paper made by alleged experts on that, saying that the amount of the damage was around 80 million euros. But, because they are good and they want to use a conservative, amount, they will just focus on 12 news, especially damaging for them, according to them, of course. And those 12 news were the alleged damage that we cost publishing was 17.3 million euros. So in order for you to put that in context, I mean, our year revenues are 20 million, so they are suing us for the almost what we our income from 1 year. So that's the thing. I mean, they decided to go in that way. We of course are defending ourselves in court. Just one thing that maybe could be interesting for you to know is that the lawsuit not only referred to the past, that was what we see as a threat, because they say that there are these, I can't remember, 65 stories especially damaging that had cost us 80 million euros in damages, or in lost value of brand reputation or whatever. There's this 12 especially bad that cost us 17 million. But they said we reserve the right to add more news in this account in order to increase the damage if we see it reasonable. So we of course read that and said, okay, this company doesn't want us to publish more things, and they are allegedly threatening us to increase the potential amount if they consider it. So that's pretty much our case. And I mean, of course, needless to say, we continued publishing the stories we thought or we think it's proper to publish, and it's good for the people and the readers to know.
Thanks so much to you both, Ángel and Miquel. It's really interesting to see, laws, particularly in Spain. We've always had major concerns about the honor and reputation laws in Spain. They seem particularly vulnerable to being exploited like this. And so I might come back to you a bit later to see what you think in Spain needs to change to prevent these types of laws being exploited. And in addition, it seems there's no cap on damages. There's no maximum amount. They can just go up and up, which is also really concerning. And that must add a lot of pressure. Flutura, turning to you now. Flutura is one of the leading experts on SLAPs in Europe, and we've been working together very closely for the last few years on reforming SLAP in Europe. So, Flutura, I wonder if you could give us a bit of background on the work that's been going on and what we need to be pushing for now.
Yes, can you hear me?
Yes.
Okay, thank you, Sarah. First of all, thank you, Julia and Miguel, for sharing your stories. It is important because if you don't speak out, it's very difficult for us to document SLAPs. So thank you very much. What you explained, the pressure you go through when faced with SLAPs, is what Daphne Caruana Galizia went through while she was alive. When she was assassinated, we understood that on top of various threats she was facing, she was also sued more than 40 times by different plaintiffs. We knew that this was not normal. We knew that it's quite a big burden for journalists to face so many lawsuits. What we didn't know was whether this was a trend, whether this is something that other journalists were facing. Since 2018, several organizations, ECPMF, Article 19, CPJ, Daphne Caruana Galizia Foundation, and other colleagues, EFJ, Reporters Without Borders, we started first to discuss with each other privately what these abusive lawsuits are they a phenomenon, what can be done, etc. And then eventually Greenpeace International joined our discussions, and they helped us, they helped our organizations to kind of have a more formal structure. We established the case. The case is the first anti-SLAPP coalition in Europe. It has more than 30 members, and we have organized our work in 3 pillars. We organize solidarity actions to support journalists who are facing SLAPPs, including human rights advocates and other activists. We work on exposing SLAPPs. We do understand that organizing SLAPPs requires not only a plaintiff, a businessman willing to intimidate journalists, but requires also lawyers who play a crucial role in organizing SLAPPs. I'm sorry for the noise here. Hopefully it will go away. And thirdly, we work quite a lot in providing practical support for journalists. Very briefly, what we've done so far is first and foremost documenting SLAPPs. There are 2 platforms. One is Mapping Media Freedom, a platform run by ECPMF, IPI, EFJ, and other partners, where we document SLAPPs. And then we have Council of Europe, a platform where we document SLAPPs as well. So if there are people who are interested to find specific cases, these are the platforms where you can find more information. On top of that, several organizations, especially Article 19, Daphne Caruana Galizia Foundation, Index on Censorship, have carried out excellent research. There are several reports on SLAPPs which provide insights not only on types of SLAPPs, but also the impact, and they also have specific recommendations. And lastly, before I very quickly touch upon solutions, we have organized and provided a lot of practical support. Now, when Julia was explaining what they went through when they were facing this lawsuit, she explained very well the stress it brings and how what the impact on personal level. And we do realize that when journalists are slapped, then the first question they have is how much it will cost us to hire a lawyer. Sometimes this is not a big problem if you have a big media house which has the financial means to support journalists, but very often it means that journalists are left alone. They don't have the money to hire lawyers. So what we do is we provide financial support to hire lawyers. This can be from 1,000 euros to 15,000 euros. We've supported Gazeta Wyborcza in Poland, Index.hr in Croatia, and another 150 journalists in different countries and working for different media outlets. I'm mentioning practical support because I want to use this opportunity to invite all those who are facing SLAPP lawsuits or other types of abusive lawsuits. Please get in touch with us. Together with Rory Peck Trust, Media Defense, Free Press Unlimited, we're all helping journalists, so there is help available. And lastly, I am aware that we have very limited time. Of course, the whole idea when we started to discuss with each other, with colleagues from different organizations, was to find solutions. We wanted to push European institutions to act. We first addressed to the European Commission, and we asked the European Commission to put forward legislative and non-legislative instruments. And then we went to the Council of Europe and we said, we want a self-standing on anti-SLAPP. And then we also asked the European Parliament to act. So far, and we're kind of proud, I want to show that we're proud with what we have achieved, because the most important aspect of our advocacy is that we've had a very positive response from European institutions. As you know, because of the way how the European Commission works and Council of Europe, it takes a bit of time to keep them moving. They reacted very fastly. The European Commission set up an independent, a group of independent experts to help the Commission to put forward legislative measures. The Council of Europe has set up also a committee. We have Julia here; she will explain in more details. And the European Parliament has published an INI report asking the European Commission to act. We're hoping by the end of April we'll have a package of legislative and non-legislative measures on anti-SLAPP. What we're asking, and I will not go into details because we don't have the time, but the most important aspect of any legislative package is to enable judges at national level to dismiss SLAPP cases early, immediately, as urgently as possible. Because as it was explained before, these are situations where plaintiffs withdraw, where lawsuits are groundless, or they are exaggerated, and defendants they win their case. But there is a difference whether a journalist is dragged for 10 years in court, or whether a court dismisses the case immediately, because then this would also have an impact towards plaintiffs. If they know that a SLAPP lawsuit will be thrown out immediately, then of course, hopefully not, but they will look for other creative ways to intimidate journalists. So this is what we're asking with this legislation. And lastly, practical support for journalists. It's really, of course, it's helpful, the fact that there are civil society organizations helping, but it should be organized at state level, and we're hoping to find support in this. Okay, I stop here. Very happy to answer any questions.
Thanks, Flutura. That was a marathon tour of all of the work that's been going on, and also the resources that are available. So one very important piece of this puzzle has been the work of the Council of Europe, which is obviously a much bigger body than the European Commission, and that's why it was very important to us that we included the Council of Europe in our advocacy targets as the leading body on the development of human rights standards. So, Julia, I wonder if we could turn to you now for some insights into the work of the Council of Europe in this area.
Yes, hello, can you hear me?
Yes.
Thank you very much. Well, I'm very happy to be present today for this important exchange. Flutura said already that the Council of Europe will initiate work on this very important subject, actually in a matter of very few weeks. An expert committee has been established, and they will work on drafting a recommendation of the Council of Europe to the member states on strategic lawsuits against public participation by the end of 2023. Now, reinforcing the action against SLAPPs is today an urgent task for my organization, the Council of Europe. We have seen, in fact, an increasingly high incidence of this phenomenon in its member states. An outstanding number of SLAPPs-related alerts were already registered in the platform that was mentioned a moment ago. In the year 2021, among the alerts that were submitted, several already concerned cases of judicial intimidation. On the one hand, we know this is not a new trend. We have already seen from studies in recent years, including the book A Mission to Inform, how judicial intimidation can prove a powerful weapon to silence critical voices and have a chilling effect on public debate, including through the testimony of Daphne Caruana Galizia. And I regret to say I opened the platform a few days ago to check where we were with the data, and I must say that the trend so far does not appear to have changed course this year. We have, I'm not going to go through the several examples that I already collected, enough to say that since the escalation as of 24 February of the Russian Federation's aggression against Ukraine, the number of threats against journalists and other media actors, including of a SLAPP character, are just countless. Already the 2016 recommendation on the safety of journalists and protection of journalism of the Council of Europe noted how legislation, how it is applied in practice, and even the mere threat of its application can give rise to a chilling effect on freedom of expression and public debate. Now, We have an annual report published by the platform's partner. The one from 2021 already identifies some main characters of Slavs. These are enacted by powerful individuals or companies, even state actors that have little legal merit, but greater means and resources than the defendants, and whose underlying objective is to silence public debate on undesirable matters by introducing burdensome legal costs. Now, of course, all these features pose a direct threat to several of the rights safeguarded by the European Convention on Human Rights. I'm surely referring to Article 10 that safeguards the right to freedom of expression. And on this specific aspect, the European Court of Human Rights has repeatedly stated that public watchdogs' task of imparting information and ideas on matters of public interest is not only instrumental for the healthy operation of democracy, but it is also strictly connected to the corresponding public's right to receive such information and ideas. Being such a complex issue, I must echo what previous speakers before me pointed out, that we should boost the protection against lapse through a combination of both legal and non-legal measures. But first of all, it seems possible, if not only necessary, to reinforce existing safeguards. Sometimes the relevant standards are available, but maybe they're not always effectively implemented. And here, for example, I will refer to the fact that SLAPs are usually marked by an evident imbalance between the power of the plaintiff and of the defendant. Now, yesterday, it really struck me in his opening remarks of this important summit, Roberto Saviano said, "La libertà di espressione è la libertà di chi se lo può permettere." This is really important. It means freedom of expression is a freedom if you can afford it. Well, of course, this should not be so. Therefore, to push back SLAPs, already the requirement, for example, to fully respect and apply the principle of equality of arms should be reinforced in national legislations, but also through international standards. Second, it may, of course, be necessary to implement new standards much more focused on anti-SLAPs legal protection. We know that SLAPs often materialize in charges brought under defamation, insult, blasphemy, data protection, or fake news laws that are particularly restrictive. And it may be necessary to review these legislations in order also to counter their discriminatory or arbitrary application against public participation. All this, of course, keeping in mind that reputation should still be legally protected, and journalists should refrain from producing defamatory work. We also have several examples of when SLAPs present a cross-border dimension when coinciding, for example, with forum shopping and libel tourism. Lawsuits can therefore result in complex international legal disputes. Now, these issues have been addressed already by the Council of Europe separately through a study and a recommendation, and in both cases, not a recommendation, apologies, a declaration. And in both cases, the issue, the conclusion was that these issues should be further addressed through a specific instrument. I'm trying to speed up because of the time constraint, and I don't have voice anymore. So I'll head to the end of this intervention just by stressing what was said already before, meaning that when we come to non-legislative measures, it is absolutely necessary to focus on measures to support SLAPs targets, including tailored awareness raising and training programs. I will not go in details, otherwise I will not leave any minutes for the question and answers, and it's too bad because there is so much to say about it. But before closing this presentation, I would just like to say that I will be really happy to keep everyone informed about the work of the Council of Europe in this subject, in this very important subject, and I'll be happy to reply to your questions either today or in future occasions. Thank you very much.
Thank you, Julia. So we just have 5 minutes, and the first question I have is to Miguel and then to Julia, about what would you like to see at the national level in Germany and Spain in terms of legal reform or measures, like financial support to journalists facing these or NGOs facing these types of cases, and what else can we as international NGOs and the international community do to support you? So maybe starting with you, Miguel.
Okay. I mean, of course, any legal, umbrella that you have at European level, and then, of course, consequently at the national level, to protect ourselves from this kind of lawsuits is more than welcome. But I think that at the end of the day, when we are talking about big corporations with lots of money, what we need is a cultural change in our corporate community in order for them to understand that they are not the owners of information. I mean, they have a role, very legitimate, and the press has another role, and we try to do it freely and defending, free speech and freedom of information. And what we need, of course, is a legal backup in order to be able to defend better ourselves from this kind of abusive lawsuits. But I think that at the end of the day, when we're talking about big companies with lots of money to spend in lawyers, they will always find a way to make your life miserable. So of course we need legal backup, but we need cultural change in the corporate community as well.
Thank you, Miguel. How about you, Julia? What do you think in Germany needs to take place? We can't hear you. No. Yeah.
Can you hear me now?
Yeah.
Yes, I mean, the situation I explained is, of course, pretty special because we are a students' newspaper with really not much money. But what I saw would have helped in our situation would have been a way to receive legal help in the way of a first some first tips or a first talk to a lawyer who can take a look at the situation and say, oh, you are right, or you are totally wrong, so that you can better be aware of your own situation. And yes.
So expert legal advice and kind of obvious, maybe something that we've been working on in CASE is a map of lawyers who can advise on exactly these issues and who can provide that.
Yes, I think that could be really helpful. So just for a first sight on the case.
Yeah. Flutura, there's a message here, a question from Paulina, our old colleague, and she's wondering in what's happening at the EU level. What are the current developments of the expert group that you sit on, and what's the legal basis for the EU to establish a measure such as early dismissal?
Yes, thank you. So I'm part of the expert group, which was established last year. And so far, we've worked as a group to discuss SLAPs, to analyze them, and also to advise the Commission with regard to potential instruments. What I can say now publicly is that by the end of April, we're expecting the European Commission to present the first package, which is a legal and a legislative and non-legislative package on anti-SLAPP. We would be able to discuss details of this package, including the legal basis, once it is public. Within the expert group, we've discussed quite a lot of elements, legal basis, and how the European Commission can go about it. But I'll be able to discuss that as soon as we have the first package public, which hopefully it will happen soon.
Thank you, Flutura. And that's brought us very neatly to the end of this very short session, but where we packed in an awful lot of information. Thank you to our speakers, to Julia, to Miguel and Angel, to Flutura and Julia as well. And please stay with the MFRR Summit. We run for another day and a half, and we look forward to briefing you on further SLAPP developments very soon. Thanks.
Hi, everyone. Can you hear me?
Yes, thank you.
Yes.
Perfect. So I'll start. We're waiting for one of the speakers, but I might just... Shall we wait a bit more for one of the speakers, or shall we just start? Right. Perfect. So I see we've got everyone right now here on the screen. So perfect. So I will start now. So welcome everyone to the panel Access Requested, Challenges to Freedom of Information. For those of you joining now, this is one of the panels that we are hosting today as part of the MFRR Summit, which focuses on the state of media freedom in Europe. So maybe you've already joined one of the panels that we had this morning on legal threats, specifically on SLAPs. And right now we will focus on access to information and freedom of information acts. So I would like to introduce the speakers that are joining me here today. But before this, just something that I want to say to the audience. You can actually write your questions on YouTube or Twitter, wherever it is that you're actually following this conference, and we'll collect them and pass them on to the speakers here. So let's start with the presentations. We have 4 speakers today. They're joining us from different European countries. So let's start with Helen Derbyshire. She's the founder and director of Access Info Europe, which is a human rights organization dedicated to promoting and protecting the right of access to information. And if I may say so, also one of the people who knows more about FOI in Europe. So we're very happy that she could be able to join us today. Welcome, Helen, and thank you. Then we move, sorry, go ahead, yes. We move to Alex Fanta. He is a journalist who specializes in technology and digital policy making in the EU, and he's currently the EU correspondent at Netzpolitik, which is a German news site that covers digital rights issues. So welcome and thanks for joining, Alex. Then we move to Spain. Miguel Angel Gavilanes. He is an investigative journalist at Cibio, which is a non-profit watchdog and news organization based in Madrid. And he coordinates also strategic litigation to promote FOI and training programs for journalists. So welcome and thanks for joining today, Miguel Angel. Yes. And we go to Veselin Meta in Albania, and he's an investigative journalist and also an editor. And he's been the editor for BIRN Albania since 2007, if I'm not mistaken. And he's got quite a lot of experience in print, TV, and online media outlets, both in Albania and the US. So thanks a lot for joining today, and welcome to you, Peter. So now that I've introduced everyone, I can also introduce myself. I am a journalist, and I am the monitoring officer at the European Center for Press and Media Freedom, which is in Germany, in Leipzig. So as I mentioned before, today we'll be discussing access to information, and we'll focus on some cases. Some of them you will see are national cases, others EU cases sent by journalists. Some of them have more positive outcomes, others not so much. Well, they're going through appeals, so we'll see. Maybe they will have more positive outcomes. So as you all know, access to information is essential for everyone, for citizens, but for journalists even more. So before I hand over to Alex, I just wanted to point out to our audience some of the threats or some of the difficulties that journalists go through when requesting information. And for that, I wanted to quote a study by the EU Eyes in Florence, which is the Media Pluralism Monitor. And just last year, they identified some of the difficulties that journalists had when requesting information, and those were long time frames to reply to information requests, administrative silence, high refusal rates, long and ineffective appeal procedures, and misuse of exemptions. So we'll talk about this and more, I'm sure, but just so the audience know what it is exactly that we're talking about. So Right now, I'm going to hand over to Alex, who will try and will explain how he's trying to find out exactly what was said in text messages between European Commission President Ursula von der Leyen and Pfizer CEO when purchasing COVID vaccine. So, Alex, the floor is yours.
Thank you. Thank you. Yes, as I was already so nicely introduced, I'm a tech journalist. I write usually about tech regulation, especially the things that the European Union is doing. And one of the things that I cover a lot is lobbying and the way that the Commission, the EU institutions interact with actors from the private sector, with large companies, with tech giants. And one thing that I've noticed is the pandemic in general has restricted the ease of access of journalists to the EU institutions. They're no longer the type of press conferences where everyone can just show up and raise their hand and ask any question. So the opportunities have become slimmer to ask these type of questions. And out of that reason, access to documents has become ever more important. And something that we've noticed is that that more and more exchanges in general in Brussels, more and more work between the institutions, between officials and lobbyists happen via text message. So the harder it got to meet in person over the past 2 years, the more people, texted each other, wrote SMS, WhatsApp messages, Signal messages, all these different types of messages. In principle, this would, this would leave a perfect paper trail for us to follow. But in practice, however, the European Commission has not archived a single text message in its document archive. That means most of the emails the Commission writes, many of the relevant documents that get exchanged via text message, they should be archived. Emails are usually archived, but that does not apply at all to text messages. And what the Commission effect has formalized this as a policy recently. They have said they will never put any text messages in their archive. Because the text messages are ephemeral, they're non-substantial, short-lived, so they don't deserve to be preserved for the future. And I think this is really problematic because this creates a loophole where basically the Commission can say anything that we don't want the public to find out about. We can just do via an app, so we can avoid public scrutiny. And the case that I brought forward to the Ombudsman was this. I saw a story last year. I saw a story in the New York Times that said that Ursula von der Leyen clinched a deal for Pfizer vaccines directly with the CEO of Pfizer via text message. It was a deal for 1.8 billion vaccine doses. With this deal, Pfizer became the dominant supplier of the European Union. I would say this is one of the, if not, let's say, the most important public procurement deal of the decade. And so in this situation, this deal was reportedly kind of finalized, clinched with the text message. So I asked the Commission for these text messages, and they said they replied saying that they didn't hold anything to my description in the document archive, which, they didn't even actually answer the question of whether the text messages ever existed, whether they were still on Ursula von der Leyen's phone, what happened to these messages. They never answered that. So I filed a complaint with the Ombudsman. And after, kind of thorough investigation, the Ombudsman, the watchdog body, found a couple of weeks ago that the Commission, by not properly dealing with my request, for not even considering whether these text messages are here or not, whether they can, whether they can be handed out or not, had committed maladministration. So it was, I would say, a slap on the wrist of the Commission. The Commission now still has a couple of weeks to formally give a reply. So they still haven't, to this date, even though they were grilled about it in the European Parliament, even though members of the European Parliament pushed the Commission, the Commission still hasn't said whether these text messages still exist or not. So this is quite remarkable. And I think here we have kind of crystal clear a test case for the question of transparency in the 21st century, namely the question, when the mediums of exchange in official business change, do our rules hold up? Can we enforce those rules on these new media? And can we say, can we say that what fell under transparency laws 20 years ago, should it still fall under transparency laws? Do these laws still apply in the way that they were written? That is the question at stake. Yeah, and I think with that, I would conclude and hand over to the other panelists.
Thanks a lot, Alex. Really a very interesting case that poses this question, like what do we do with the laws that we had that were not thought for a time with text messages and so on. So we'll be following that, and I hope you can come back next year to the summit and tell us that, well, you managed to get the information. So we'll be waiting for that. And we also have 2 national cases. As the audience knows, each European country has its own FOI law. So we'll be looking at we've just looked at EU cases, but we'll also look at national cases. But before that, I want to ask Helen to give us an overview of the FOI situation in Europe so we can get the bigger picture here, and then we'll move on to other case studies. So Helen, whenever you want.
Thanks very much indeed, Nils, and thanks. Good afternoon, ladies and gentlemen. I'm also sitting in Madrid. So it's greeting everyone from Spain, not far from Miguel Angel, in fact. There are a number of issues which Alex has just raised, and I'll try to build on some of the things that Alex identified, as well as giving that general overall picture of the right of access to information around Europe. Access Info, sitting here in Madrid, Access Info Europe, we work on promoting stronger national access to information laws, and also very much on the legal framework for accessing documents at the European Union level. We look at the laws, and we also very much help requesters, and in particular journalists. Journalists are by no means the only users of access to information laws, but journalists and civil society are often amongst the most active users. And we have a platform, asktheeu.org, where you can actually see over 10,000 requests that have been submitted to the EU and see what answers were received. And for journalists who are listening to this and who are interested, we have a pro version of that, which has a dashboard inside it where you can manage your requests and even decide whether or not to publish the requests and the answers. You can keep them out of public view until your article goes public, or your television report or whatever it might be, and then you can publish all the requests and the answers. So we do try to provide tools for journalists to help you exercise this fundamental right. The first point I'd like to emphasize is, yes, this absolutely is a fundamental right. And Alex was talking about what's changed in the last 20 years. One of the things that's changed is that we've had a recognition from international human rights tribunals, including the European Court of Human Rights, and from many other bodies, that this is a right linked to the right to freedom of expression, not a right exclusively for journalists by any means. All of us as citizens have a right to get information and express ourselves, but particularly strong, an important right for journalists. The European Union upgraded the right of access to information in 2009 and made it a fundamental right of EU citizens and residents to have access to documents held by the EU. This is interesting because the regulation that Alex was talking about, you said 20 years, it's from 20 years ago. So we've got something interesting, a regulation that's written before the strengthening of the right itself to a fundamental right. If we look around the European region, the larger region of the Council of Europe, the 47, or I guess I should say 46 countries now, because Russia's been suspended from the Council of Europe, that European region, and Belarus is not a member, that European region, every single country has something that they call an access to information law, at least on paper. I have to say that the laws vary, and we'll be hearing from Besar about the challenges with getting access to information under the Albanian access to information law. But on paper, at least, and the difference between paper and practice is quite something we know often, on paper, the Albanian law is one of the strongest laws in the region, a younger law, which is very strong. But we also have countries such as Austria, which has one of the weakest laws, not only in the European region, but indeed in the entire world, and where people are trying to press for, I think that's your native country, right, Alex? People are trying to press for a stronger access to information law. So the actual legal framework that allows you to exercise this right does vary in practice around the region. And as a result of some challenges coming from different countries, including from Hungary, from Serbia, from Croatia recently a case, from Ukraine, we've had some very interesting cases that have got to the European Court of Human Rights and have helped strengthen the definition of this right. There are also cases which have been taken to the European Court of Justice. Access Info took a case about getting access to information from the Council of the European Union about what member states were discussing in the Council. So that's something that's really important. Where we see problems in practice, there are solutions. It's possible to take complaints if you're requesting information from the European Ombudsman, to take complaints to the European Ombudsman or to the European Court of Justice. At the national level, in many countries, there are information commissioners or commissions which oversee this right and which allow journalists, NGOs, other members of the public to take complaints, in addition to going through the courts, as we'll hear in a moment from the Sevilla case that actually ended up in the courts in Spain. The difficulty for journalists is actually making use of these opportunities to appeal. And there it's important to look at the civil society network around Europe, which supports journalists and can help journalists with writing. Last night, finished helping a journalist write an appeal to the European Ombudsman, a complaint to the European Ombudsman, for example. So that's something that we do. And we also have networks of pro bono lawyers who can help, because it's really important that where these laws are not properly applied, we actually take action to defend them. And as we heard, it's maybe a decision from the European Ombudsman is only a slap on the wrist for the Commission. Let's see if the Commission takes it seriously or not. But it is really important for helping to define the nature of this right. What we're seeing in practice is really interesting. Often the language of the rules is not the problem. And at the EU level, for example, the definition of documents is very clear. It's any information recorded in any format. And we in the European space have the world's first binding convention, the Tromsø Convention, which also defines information as information in any format. But in the mind of the bureaucrat, it's still the PDF. And so what we tend to see is we've had to fight to get emails and Excel sheets recognized as documents that we can request. And now the next cutting edge battle is on with text messages, as we've heard, and with algorithms, as we're going to hear. So getting these access to information laws updated for the information age is sometimes not a matter of changing the law. It's a matter of pressing to ensure that they're interpreted in a way that allows us to follow decision making. And as a last point, because I see my time is almost up, something else that's really important consideration for journalists is timeframes. It's great, yes, I have this right and I can request and I wait 3-4 weeks to get my answer, and then I appeal internally, and then I go to the oversight body and appeal, and then I go to the courts. But I know from Access Info's case that we won, it was 5 years between the initial request and the final ruling in favor and me getting the document. So that's a lot of time. It's worth doing because you can establish important principles. But something else that it's very important to keep working on is greater proactive publication of information. And that's something that we focus on, for example, in areas that are important for anti-corruption work, like public procurement, company registers, which is a big battle to get those open in Europe right now. And the crisis with the invasion of Ukraine has shown the importance of having these data sets open so that we can track corruption and also illicit financial flows. So there's a lot of work to be done in opening up certain data sets in order that journalists are just able to go and check and make sure that everything is being done correctly. I'll stop there. Basically, the conclusion is we've made a lot of progress. There's still more work to do, and we're working on it. Thank you.
Great. Thanks a lot, Helen. And we'll definitely come back to the topics that need to be open still. And we'll talk about procurement. But I'm just going to move on to Miguel Angel. I know you wanted to share your screen, so maybe you can do that. Miguel Angel is going to present a case in Spain, and you can already see the slide, so I think he can explain it himself. It's about algorithms, so I think it's very, very interesting and very recent, so go ahead.
Okay, thank you. Thank you very much, Neil, for the invitation, and good afternoon. This story I'm going to tell you is about, it began in October 27. Part of the CVIU's activity consists of analyzing the small print of law, and that details that governments do not tell in their press releases. So we started publishing about the so-called social bond, a subsidy created to mitigate energy poverty, which had a complex set of rules. So over time, the beneficiaries of this subsidy were much lower than the government's estimations of the potential beneficiaries. So we started to detect some entry barriers. For this reason, and as a procedure was complicated, CVIU created a tool to help people find out if they were eligible for the social bond and explain them the next steps. It was then that several people told us, while our tool was telling them that they were entitled to this social bond, they were being denied. The processing of the social bond is carried out by the electricity companies, and they do it through a public application which is developed by the public administration. So before suspicions of design failures, we request the source code of and some other technicalities to the government. What we found that the government denied our request for three reasons. The first one is because it would expose personal data, or because it would jeopardize the security of the administration by exposing its vulnerabilities in the code and so on, and because of intellectual property reasons. We appealed to the Spanish Transparency Commissioner, the Consejo de Transparencia, which denied us access to the tool's source code, but allow us access to some technical documents, which are the technical specification and the result of the test carried out to check the application. And we have a partial answer from the administration, thanks to the Spanish Transparency Commissioner. And with these documents, we demonstrate that the application had errors in its design. For example, the design created dead ends that return the message of impossible to calculate. As in this case, the case of a widowed woman who was entitled to assistance, but entitled to receive this subsidy, but she was denied. Instead of a public employee reviewing her case, the response was let's say, automated. So as I don't know if you can see it in the image, but is this impossible to calculate message is what she received as answer. So what started as an investigation into access to public subsidies turned into a court case about the transparency of the code of the application created and used by public administration in its decision making. So earlier, we started this case. We requested information in 2017, and we requested information in 2018, and we started in the court in 2019. And earlier this year, we got the first sentence. Our A request for access to the code was rejected, and we were also ordered to pay around 2,000 in costs, 2,000 euros, sorry, in costs. And the judge based his decision on what we understand to be generic statements made by government and the Spanish intelligence agency, the Centro Nacional de Inteligencia experts. They said that the dissemination of the source code of any program would allow attacks and the exposure of sensitive databases, something that even the public documentation on the application itself contradicts. If all these protocols were followed, the government could, according to the Spanish transparency law, omit these sensitive parts and give us only the part of the code where the calculation of the social bond is made. And we have appealed this first sentence because we understand that verifying a source code is not hacking it. It is analyzing decision making by public administration, and I think we think that this is also what journalism is about. And that's it. Thank you very much.
Great. Thanks a lot for explaining that case. And as I said to Alex, we're looking forward to the resolution of that, and let us know. And we'll invite you again next year, hopefully with good news. So I have more questions for you, but we'll just ask them later on. The audience that
I think Nails is frozen. Yes. Should we carry on?
Can you hear me now?
Yes.
Okay, so yes, so we go to Besser and to a case that I think it's really interesting for two reasons, because it has to do with minutes of meetings, which are sometimes quite controversial, and the countries have different approaches and different institutions. And it's also because it's got to do with judicial bodies, which are usually quite secretive. So let's go to Besser, and I think the outcome of that one is a little bit more positive, hopefully. So go ahead.
Well, Niels, thank you very much for the invitation. As Helen said beforehand, Albania has quite a progressive law in terms of freedom of information, which was passed in 2014. Certainly, we've tried as an organization, but also as journalists, to use it for many years. We hope that this justice reform that was passed in 2015 and implemented in the last few years would have made the special judicial institutions more transparent. Unfortunately, we found the hard way that judicial institutions, although the reform process would have aimed to fight corruption and let's say ties to organized crime and links to organized crime, has become more closed than they were before. One of the challenges we had is to get access to the meetings of the High Council of Justice. Although the law says that the meetings are open to journalists, because of the pandemic, they were not transcribed, and the journalists couldn't, let's say, connect online, or they could not be present in the room during, let's say, the deliberations. When the meetings were actually transcribed, they were so much anonymized of, names and courts and everything else, so they were pretty much unreadable and something that didn't inform the public. And this was a period where important decisions were being taken by the High Council of Justice, particularly on the deliberations on the appointment to the judges to the Supreme Court. When we asked the High Council of Justice about the documents, they kept giving us different answers. We're talking about freedom of information request. First, they claimed that they didn't exist because the meetings weren't recorded. Then at one point, they claimed that they were classified as state secret because there were classified information taken by the security services regarding let's say, the background of these judges, and this would be a breach of, let's say, of state secrets. When we actually appealed to the commissioner ruled in our favor. But the decision wasn't implemented properly by let's say, the High Council of Justice. We sent the case to court, and the day that the court had the first session, the High Council of Justice actually gave us the documents, basically the transcripts that we we were looking for. They admitted in court that there were no state secrets in there, although these were officials replies that they would answer and they would give to the, let's say, to the R for Freedom of Information request. This was a small victory, but this was not the end of the war. I mean, we keep filing requests and we keep getting the similar answers by the High Council of Justice, or they keep behaving the same way. Unfortunately, this is a protracted battle, because every time we file a request, although the law in Albania spells out that you should answer in 10 days, they wait for 10 days to ask for 5 more, and then they will give you a half answer or an answer which is not proper. Whenever we have cases that the commissioner, even if the rules in our favor, the institutions tend to send the case to court, even the commissioner itself, but also us as a third party. Just today, we had one of our journalists in the administrative court, because the appeal special court against organized crime and corruption has filed an appeal against a ruling of the commissioner, which granted us access to a verdict, which was the verdict for Luxembourg for a high-profile corruption case. When we requested the document, the judge said that the basic, which is the media, actually the media judge there, said that we can access the document based on judicial rules as being an interested party. And we said, no, we are basically requested under Freedom of Information law. We are granted access. We're not an interested party. We are granted access to this document because the public, just like us journalists, has an opportunity to gain access to court verdicts. This is something guaranteed and enshrined in the Albanian constitution. It's not something foreign. All court verdicts should be public. And it's something that routinely is applied by the Constitutional Court and let's say the Supreme Court. Other lower courts have found many excuses. Either the priority, they say that there is a priority about the criminal code compared to the, they would say that the criminal code gives an upper hand to the Freedom of Information law. So criminal code, we should be regulated by the criminal code. Also, they use, let's say, regulations which were based on previous versions of the Freedom of Information law, which is outdated, or they would confuse, for example, proactive transparency with on-request transparency. For example, if they have a regulation, how they make public, let's say, court verdicts on databases in terms of anonymizing them, they would use them for the same thing for the Freedom of Information request. Or they wouldn't make any distinction between cases when there is a high public interest or a case that there is, let's say, sensitive data about, let's say, or it's a family dispute or anything else. We've tried for many years to get the Freedom of Information Commission in Albania to actually use, let's say, public interest, which is enshrined in the law, as a, let's say, a measure of deciding if certain information should be public or should be anonymized, but that's not the case in many cases. It's particularly about the judicial, let's say, minutes. Also, well, the positive effect, at least of this court case that we had, although it lasted for only one session and we had to actually pay the costs, because I mean, for some reason, and we are appealing that, but the judge wasn't sure that how we could, let's say, dispute the cost when we were withdrawing the case because we got what we wanted, although we spent time and effort and let's say even money to send it to court. In any case, the positive thing was that the parallel institution, the high prosecutorial councils, after doing the same thing for almost 2 years, refusing to grant access to journalists to these meetings that were held online because of the COVID pandemic, decided to, also under public pressure from media and journalists who kind of started a campaign over social media against it, to grant access to journalists to these meetings. But this has not been a one-way win, because we had problems many times when we connect online. We can be thrown out of meetings. The institutions can claim that something went wrong, or we didn't register it in the right time. So when you think about it, the worst case, although we're fighting this battle, which is ongoing for what we believe is in public interest and information should be public and accessible to all, like court verdicts, we have the judiciary fighting us. the judiciary should be on our side in terms of, you know, regulating other institutions when they don't like apply properly the freedom of information law, is the one who's taking us to court. So it's a strange situation where like high profile judges are sending you to court because they want to refuse to access to documents, and we can see a future that this may end up in probably in the European Courts of Human Rights. The problem with it is that because Albania has been undergoing this very painful judicial reform, every case in the administrative courts takes years, at least 4 or 5 years to go through. And this will probably be a long battle that not all media and journalists are eager to, let's say, get involved, because it takes a lot of resources, it takes a lot of time, and understandably, a lot of the information that we're seeking now, it's going to lose value because it would be because of time and the things changing. For example, we had cases during the pandemic, even when the commissioner ruled in our favor, there was so much changes in terms of COVID data that it was useless 3 months after. I mean, another problem that we've noticed is also the thing about precedents. Commissioner in Albania, although does a really good job in holding hearings and getting all the parties together, I really think that there is no need to have a hearing every time that you file a freedom of information request. If the case is quite clear from previous precedents, the commissioner could rule outright. There is no need to hear both parties again and again and again for the same type of information. It is clear that certain type of information about government spending or, let's say, official spending, it is in the public interest, and hearing both sides, it will just makes the process a bit more cumbersome, makes the let's say time consuming for journalists, and certainly we see that there is a certain tendency to try to draw up these battles from the institutions who will always answer cases or the request at least starting from 10 days, which is the maximum amount of time allowed by law, or they will wait for actually to start giving an answer when you appeal the request. So I think it's a struggle. I think it's a struggle in public interest, but we would have hoped that when the progress that were made during the last few years in terms of implementing the law would move on in the right direction, but we also see setbacks. So not everything is perfect, and it's always a struggle for reporters to get their hands on information. Unfortunately, there is a problem, I think, that has to do, at the core of it, it's a problem that has to do with the mentality of people who have access to this kind of information, the judges and the prosecutor, the public officials, who see information as a tool that should be trafficked. It's not that data doesn't leak in Albania, but they see it as a way to exchanges for journalists, with journalists for like a favorable coverage or to close an eye on certain things, or to build up a relationship which in its essence is corrupt and doesn't serve the public interest.
Yeah, great. Thanks a lot, Fesser. That was very interesting. And many of the things that you were saying reminded me of Spain too. So I think we can relate. Yeah, so thanks for that. And I think the first question that I have for this, I mean, you've all described lengthy processes to access information, having to go to court and so on. So this is time consuming, resource consuming. So I guess my question is, as journalists, how much do you actually use this tool, and how useful do you think it is? And if something had to change, what would be? Like, is it timeframes, the thing that bothers you the most? What is it exactly that you think should improve right now? And also wanted to talk about the role of information commissioners or the ombudsman. I mean, how useful has that been for you as journalists to take cases to these institutions? And maybe we can start with Miguel Angel. You could talk about, you've got quite a lot of experience with the information commissioner in Spain with the Transparency Council, and maybe we can move to Alex later on, and you can tell us how useful it was to take the case to the ombudsman.
Okay, yeah. Here the Spanish Transparency Commissioner is useful to, I mean, at least you have someone when you need to appeal to anybody, there is a Transparency Commissioner, which is common in the European countries. But the problem is their independence. I mean, how the commissioner or the president of the Transparency Council in Spain is appointed. How his name is elected by the government, the Congress. How is, I mean, and if these people is, or this person is independent from the government or from the government party. I mean, this is an issue, and but is useful because you have a set of rules of the because of the transparency law, and you have someone to appeal when you are not agree with the information. But yeah, I mean, when you said about the lengthy processes, it's true, because you have to request the information, you have to wait. In the best of the cases, you have only 1 month, but it could be the double or 3 times. And then you have to, if you don't have the information, you have to go to the Spanish Transparency Commissioner, which is 3 months more. And even now they have a problem with the procedure, and they are taking more time than what is observed by law. And yeah, and the other side is I don't know if that happened in other countries, but which we have experienced here is when a government change, they also change how they observe the law. I mean, how they apply the law, because sometimes we have seen that they denied some requests that we had in the past with other governments, and it's not precisely sensitive information. And so sometimes I don't know if it's about the culture of I don't know. I have the question for the rest of my colleagues, is if this is common in the countries also, because for me it's also an issue.
Shall we go to Alex, maybe? You want to take that?
Yeah, sure, definitely. Yeah, I very much agree with what Miguel said. I think that freedom of information is a necessary part of the toolbox for journalism. I think it is helpful even for those journalists who don't use it, because freedom of information creates a new reality for the public administration, where they have the reasonable expectation that things will eventually become public, so they have to be more transparent. When I was a journalist in Austria, it was very frustrating to see that, for the want of a whistleblower or a leak, when the public administration refused to give me access, there was simply no other way. So FOI provides this wonderful alternative, this wonderful lawful way to access info that the government would otherwise withhold. And I think in that respect, it is a very important perspective and a human right, as Helen mentioned. And I think that the Information Commissioner, also the Ombudsman, even though the European Ombudsman's decisions are non-binding, they're still important, because the Ombudsman helps to make the story about transparency. If you can't get the information that you wanted, then at least you can make the story about transparency. Say, it allowed me as a journalist to say, I don't know what the information is, but I know that they're withholding it. So there must be something about it that is interesting. And I think, the possibility to have an independent body call out the administration for their lack of transparency is a very important thing in the toolbox of journalism, and also provides a means to make a story, create a narrative around that.
Yeah, absolutely. I see that we're running out of time, but I actually have a question. It's 2 questions actually for Helen. So I'm just going to ask them both at the same time. And since we're also trying to see, well, what is the solution, or some of the solutions that would actually help journalists. So one of my questions is, seeing this, how much of a problem is it that each European country has its own law, and that's not harmonized in a way as we have GDPR and so on? Although we have Trump, so that's a different thing. But how much of a problem is that? And do you think we could harmonize it, or should we aim to harmonize that? And then you also mentioned before some of the things, proactive transparency, that we needed to look at, like procurement and beneficial ownership, registers and so on. Which are the topics we should be focusing on in the coming months? I'm guessing EU recovery resilience facility, that would be one, then beneficial ownership. So if you could point to this so we can finish on like what to look for in the coming months.
Okay, thank you very much, Neos. You read my mind with your first question, because listening to the other three speakers, I was already going to make a point about the different interpretations that we're hearing, the challenges that we have country by country. There's something incredibly inefficient where, for example, in Spain, Miguel Angel and the colleagues at Civio are having to take legal cases and pay legal costs for something which in another country, France, the Information Commissioner has ruled very clearly, and it's been accepted, at least to a certain extent, that algorithms constitute a document which can be accessed. That Besar in Albania is trying to get minutes of meetings, or Alex is trying to get text messages. That's a bit more cutting edge, but which in some countries have already been obtained. So I think we have two problems. One is that the legal frameworks are different, but much more that the interpretation of them is different. We're trying to raise the minimum standards. Not all countries, only 11 so far, 12 when Spain have ratified the Tromsø Convention in a region of 46 members of the Council of Europe. And I think absolutely key to this is information commissioners, first of all, having them. Then the points that Miguel Angel was raising, they're not always so independent. They don't always have, like the European Ombudsman doesn't issue binding decisions. So we need to have a strengthening of the infrastructure that helps protect this right. The laws themselves are often not bad. Some of them could be improved, definitely. But I think it's more questions of implementation and oversight in order to ensure that these laws are working in practice. Now, if we had some kind of clearinghouse for good jurisprudence and that we had better ways of exchanging information, if within the EU we could mandate that everyone meets a minimum standard, I think that would be a game changer for actually ensuring that the laws are interpreted in the same way. It's a whole topic to discuss. On your other point about proactive publication of information, yes, right now the big battles are ownership of companies. We're waiting for the European Union to take a decision, and it's dragging its heels on this, whether or not to really require member states to open up company registers. There's a huge paradox here. Ukraine had been one of the first countries in the world to have both a fully open public procurement and open company register. We've been urging in recent days that to support what's going on in Ukraine, perhaps we could mirror what they've done in terms of their anti-corruption and transparency initiatives, at least as a sign of recognition of what had been achieved there. Albania, with its really strong access to information law, we sometimes see that some of these transitional democracies have achieved things, whereas in Western European countries, we're still trying to get these data sets that we clearly need to be opened up. And the spending of the recovery funds, we know that when there's a lot of money spent in a short space of time, that creates huge risks of misspending the money, not necessarily deliberately, just spending it badly, and of corruption and fraud taking place. It's imperative that we have full transparency around these funds. We don't have it, but there is a whole network of journalists that we are working with and supporting to try to press for greater transparency so that we can ensure that the money is spent well, both to help us recover from the pandemic and to address challenges like climate change. So the agenda of what is needed is very clear. I think our challenge is securing the political will to do it. And that is also, as a last thought, where the media can play its role. Alex was talking about the expectation of transparency when you have these laws. Something that journalists can do is write about this right and remind everybody in society, the public, and also the political leaders that this is a fundamental right and that they really should be ensuring that we have proper transparency, so that it really becomes something that is part of the public debate and agenda. That's where journalists can help us. We try to help journalists, but journalists can also help us. Thank you.
Great, that was great. I think we can finish with that sentence, and that really summarizes what we were trying to do with this panel. So I'm afraid we've run out of time, and I just want to thank you all the speakers here today. That was very interesting, and I hope we can have further discussions on this and also focus more on FOI as a right for journalists, and we'll try to do that also in the coming months. So thanks a lot, all of you and the audience that has gathered here to listen to us. Thank you very much.
Thank you very much.
Thank
Thank
you.
you, everyone.
Thank you.
Welcome, dear guests and participants of the MFRR Summit. My name is Luhze Kinkel. I'm the Managing Director of the ECPMF. I will have a talk now with Vladimir Motorin. Vladimir is the editor-in-chief of the website of TV Dost, and I'm very happy that we have him with us. Welcome, Vladimir.
Hello, Luhze.
The situation, as we all know, is devastating in Russia. It seems that Vladimir Putin is suppressing media freedom and press freedom in total. And Vladimir is one of these persons being affected by that. Vladimir, the TV station Dost, better known in the West as TV Rain, stopped working at the beginning of March. Could you tell us what happened in these days at the beginning of March so that you had to stop working?
I think that we have to start from the end of February, from first days of war, or the military special operation, as the Russian government says. 5 hours after the beginning of the war, we, not only Dost, but every media in Russia was informed about new rules. Our government, through our media regulator, Roskomnadzor, told us that we can broadcast and write about facts in Ukraine, only facts that were provided to us by Russian government. Other facts became fake news. After that, we had consultations with our lawyer, and we decided to write in every news and in every piece of broadcast. We told our audience what Russian military or government said about these facts. But very often it was phrased like Russian military or Russian army did not comment these facts. But that was not enough, because 2 days later we received the first notification from Roskomnadzor. It required from us to delete one text on our site. This text was written on facts that was provided by Ukrainian officials. But before the war,
Welcome, dear guests and participants of the MFRR Summit. My name is Luhze Kinkel. I'm the Managing Director of the ECPMF. I will have a talk now with Vladimir Motorin. Vladimir is the editor-in-chief of the website of TV Dost, and I'm very happy that we have him with us. Welcome, Vladimir.
Hello, Luhze.
The situation, as we all know, is devastating in Russia. it seems that Vladimir Putin is suppressing media freedom and press freedom in total. And Vladimir is one of these persons being affected by that. Vladimir, the TV station Dost, better known in the West as TV Rain, stopped working at the beginning of March. Could you tell us what happened in these days at the beginning of March so that you had to stop working?
I think that we have to start from the end of February, from first days of war, or the military special operation, as the Russian government says. 5 hours after the beginning of the war, we not only Dost, but every media in Russia was informed about new rules. Our government, through our media regulator, Roskomnadzor, told us that we can broadcast and write about facts in Ukraine, only facts that were provided to us by Russian government. Other facts became fake news. After that, we had consultations with our lawyer, and we decided to write in every news and in every piece of broadcast. We told our audience what Russian military or government said about these facts. But very often it was phrased like Russian military or Russian army did not comment these facts. But that was not enough, because 2 days later we received the first notification from Roskomnadzor. It required from us to delete one text on our site. This text was written on facts that was provided by Ukrainian officials. But before the war, it was true information for Russia. But after the beginning of war, it became a fake news, according to our government. So we deleted this information because Roskomnadzor said to us that site would be blocked if we did not do that. The same notifications was provided to other media also. 2 days later, it was the 1st of March. The Office of General Prosecutor published a statement. It was written there that TV Rain distributed extremist materials through social media and through the site. That is why General Prosecutor's Office asked Roskomnadzor to block site of TV Rain, and it was blocked the same day. It was a very serious statement for our media, because in our criminal law we have an article for distributing extremist materials, and people under this article can be sentenced to 10 years. So we decided, the head of our company and the founder said to us that we have to leave the country if it is possible. A lot of journalists left country this day or next days.
Vladimir,
Nowadays,
you said, well, 10 years. It's 10 years jail sentence.
yes,
Someone who is
that's true.
distributing
That's true. Yes. That's the article which was used against opposition in Russia, and some activists that supports Navalny, for example, are sentenced with this article. So it was very dangerous for us to stay in Russia. Around 30 or 40 journalists of Dost left the country at the beginning of March.
It was not only Dost that was targeted by the government, but it was also Radio Echo Moscow and other small media outlets. You already said a sentence about that. It seems that President Vladimir Putin is not only waging a war against Ukraine, but at the same time against quality journalism in general. Why is that, and why is it now?
The statements of Russian officials are very different from what people in the US or in the USA or in other countries read about Ukraine, about situation. And just one example, this war started 3 weeks ago. But there was only one time when Russian officials announced the losses of Russian military. It was more than two weeks ago. So it is very important, I think, for Russian government right now to close other news outlets that can tell alternative facts about Ukraine, because I think that a lot of questions will appear, people will ask questions about this war, and one of the questions that we will ask people about this war, how many people, how many Russians died there? And it is very important for Russian officials right now to close big media, maybe small media also, that can provide these facts to people in Russia.
Okay, so the idea, the intention is to really preserve the narrative, and the narrative is, of course, that it's only a military operation, that everything is successful, that everything will be done in a few days, and that you don't have casualties on the Russian side. Because the facts are different, and also the reality is different, and you cannot suppress reality for a long time. But obviously, Putin is trying hard to do so. Experts even fear that the Russian government will isolate the country from the global internet. Do you think that this will happen, or is there a probability in that?
Well, our government told to us that it had technical capabilities to do so, but nobody knows whether it is just words or it really can do so. I think that only the future will show what happens.
The messenger Telegram seems to be the last option for the Russian population to get independent information. Do you see that the same way, and are there any other tools also?
Telegram became the main source of independent information for public in Russia right now, which is not blocked. We had a lot of media and social media that were blocked in recent weeks, but Telegram is not. And I see that a lot of new people appeared, mass audience appeared in Telegram in the recent weeks, and we see that news channels such as Medusa or other independent news channels quickly they became bigger and bigger. Some of these channels have audience more than 1 million person. But this is not the only source of information for Russia, because Russian people can use VPN to access to blocked to social media that were blocked. They can read and write to Facebook, to Instagram, to other blocked news media, for example. And Russians did so. I saw statistics, and these statistics, and we can say that there are a million VPNs on different gadgets, that millions of Russians had VPN right now, and they can read independent news media if they want.
I mean, the main source, obviously, for the population in Russia is still TV, and the TV is influenced by the state's propaganda. What do you think does the propaganda do to the population? Does it really increase the loyalty of the people, or does it also make the people critical because they have a sense that it's too much, that it's probably fake, that it's probably lies? So how are the people reacting in Russia?
Propaganda is very effective in Russia, and and it is not only on TV. It is in the internet also, and it was on YouTube before YouTube deleted a lot of channels in Russia with propaganda. And I saw sociological research from Levada Center. It's one of independent sociological companies in Russia, and it said that at the end of February, around 60% of Russians believed that NATO and USA was the reason, was the cause of escalation and the Ukraine in the beginning of this year. So we see that propaganda is very effective in Russia.
Mm-hmm. Vladimir, I mean, there will be a lot of exile media because a lot of journalists are now forced to leave the country. So what I expect is that there will be exile media in neighboring countries, but probably also in Germany. What kind of role will these exile media play for the public in Russia?
I think that it is effective right now to write about Russia from outside of Russia. And we see some very influential media that wrote about Russia outside of Russia. For example, Medusa. For example, Russian edition of BBC. And some other media. So it is a lot of all these media have big audience in Russia, and a lot of Russians that young Russians, for example, they read these media. But nobody knows what will be next month, at the end, in the summer, at the end of this year, next year. And if there will be iron curtain and the internet, which cut Russia from global web, I think that it will be more difficult to write for Russian audience outside of Russia. Mm. But I think that this media can be very important, maybe next year, maybe next years, nobody knows when there will be big changes in Russia, and maybe Russia wants independent media one more time.
Is there any chance for TV Rain to be re-established in exile?
Well, we all staff hope that it is possible, but only Natalia Sindieva can decide whether she wants to do that or not.
What do you think, Vladimir? How can and should the EU respond to what is Putin actually doing to his war on information? What is our job and task as the EU?
I think that European Union can help journalists that have to leave Russia right now. Many of them tried to do their own channels on YouTube, for example, but most of them have no work right now, and that is the big problem for them. And I think that European Union can help these people to find, not to find, but can help these people to do their work, the work that they like and want to do. European Union can help them to continue to be journalists and journalists for Russia, for Russian audience.
What are your personal hopes for the future?
Well, I don't see any future for me in Russia right now, and I think that there are security issues for me in Russia, so I decided to try to work outside of Russia, but I think that I will work for Russia.
Thank you very much, Vladimir Motorin. I think the Russian journalists, wherever they are in the EU, need our solidarity. Thank you for this interview.
Thank you, Luhze, for interest to Russia.
Thank you.